Hello, today is the May Legislative Review Committee meeting, and thank you for joining us, whether you're watching now or later. I would like to amend the agenda to make sure that we schedule and pick a date at the end of our meeting for the July meeting. I need a motion for that.
So moved.
Second.
All in favor?
Aye.
Aye.
Unanimous. Okay, we'll get to that. And I know Sarah will make sure we don't forget. At this point, I would like to get the approval of the minutes from April 1st, our last meeting.
Motion to approve.
Second.
All in favor?
Aye.
Aye.
Aye. Anybody opposed? I think that was unanimous. Okay. All right. So let's get to work. And who's presiding in Blaine's absence? I guess
I can kick it off.
Could you do that, Sarah, so you can make sure the right staff member is doing
Sure.
what we expect? Thanks.
Of course. So we last talked about the local civil rights legislation ordinance in our April 1st meeting. And in that conversation, there were a number of changes and questions that came up from committee members that you've asked staff to research and to revise within the ordinance. So following that conversation, Chief Assistant Attorney Hines and Crystal Coburn, our inclusion officer, they were able to meet and collaborate to provide some updated documents for y'all. So since the last meeting, Chief Assistant Attorney Hines provided a revised draft of the non-discrimination ordinance. So you'll see that in your files dated April 30th, 2021. So that will be the most recent draft copy that we'll be referring to. And she also incorporated those changes that our inclusion officer noted. So if it's agreeable, Madam Chair, I'll go ahead and turn it over to Chief Assistant Hines to discuss what the changes were.
That sounds good. And I'm wondering, committee, should we be sharing the document for the meeting?
Great.
I mean, screen-wise, what do you guys think? Let's do that. Sherry, is that good with you?
That's fine. Would you like me to share it, or would you like to share it?
Yeah. I definitely would like you to have it with what you're talking about. So we're.
Could you repeat the date on that last one?
I think it's 4:30.
Okay, that's what I have open. Thank you.
Because that would have been ready for the beginning of May meeting that got moved.
I'm just sharing my screen to make sure I share the right one. There we go. Okay, can everyone see this? Okay, great. So just really quickly to run through the changes. Most of these actually are Crystal, so I don't want to steal her thunder, but she made some really excellent additions to the recitals that you can see here about the goals of in prioritizing and expanding inclusion and diversity and equity throughout the government. We made some really minor changes, again, really from Crystal's review to some of the language that you can see here. And then we changed, I know one of the things that the group had discussed was wanting to change citizen to resident. And this was the only one that I left as citizens just because we were talking about specific constitutional protections and rights. And I thought that was most appropriate, but everything else has been changed to residents to be as inclusive as possible.
Right. And on that note, it occurred to me that even resident is somewhat limiting, because we want to say community member, because sometimes we have visiting community members. You know what I mean? They might just be here for a weekend and experience something that we definitely aren't wanting to happen. How would that work out? Committee, do you think we would just want to put community member versus resident?
I would be in favor of that, given that people who may work in the county but not reside in the county would fall under, seek out remedy that is specified in this ordinance. Right.
Okay, so citizens gone, resident substituted for community member.
We're talking about throughout the document or in this whereas?
I'm thinking it's relevant throughout, unless we have go ahead, Mara.
I'm sorry. I was just noting, I was actually, once I zoomed back in and look at the document itself, we're not proposing to change if you could scroll down just a little bit to the very next
Sure.
paragraph, Attorney Hines. The United States Constitution provides for the equal protection of all citizens. I don't think we can change that, since that doesn't necessarily say all community members within the Constitution. But I think that for our purposes, throughout the rest of the document, we could probably say community members. Does that make sense?
That's a good call. We can't change the United States Constitution as much as we would like to.
I know.
I mean, if we got started, we would never stop on that one, right? Yes. Go ahead, Carol.
Can we possibly do a document search to find out if it makes sense in all these places? I just would, I just want to clarify what we're doing, where we're doing it. I'm trying to do it at my end.
Right. Well, if we can work on content here in the committee, and then we can let that detail be run through, and then look at that. How about that? And then
sounds good.
Okay. But as we see it coming up now,
we'll check.
It's looking like it would fit.
Yeah. And could
No, it's fine.
That's for raising my hand and being so rude.
Well, it's different with screen sharing. It's really hard. Now I know what Kelly means when I can't see everybody. So I just chime in, guys. Go ahead. Go ahead, Mariah.
Okay. Do we all agree though that wherever appropriate, making that change, and so not necessarily if we otherwise get through this today, we can, if there's any tweaks we need to make, we can do that at the agenda setting or voting meeting, but not necessarily returning to ensure those each of those instances is
right
good in a future meeting. I just feel that's something pretty low level that we could approach outside of meeting perhaps, or once this exits committee.
So we're just changing all these residents to community members.
That's right. Sherry, what are you thinking?
Well, I just wanted to make a point, which is that I worry that even community members might still not quite encompass exactly what you meant. Because I think there's an argument that if someone is only traveling here for a weekend or even a couple hours, that doesn't necessarily make them a community member. So maybe we just need to have two terms. So whether that's residents or community members and visitors. To make sure we're just really covering that whole gamut.
Yeah. Mariah, I think we covered a little bit of that back when we were doing sort of the license holder education stuff.
Yeah.
Does that sound familiar? That we were trying to make it community member and visitor and or?
Yeah.
So
I think that works.
I find it's interesting that it's exciting that we're at this point of picking these details. But I guess because we were working on bigger content before, but I agree to let this process through, Sherry, and then you can keep giving us reminders of how it's going to be inclusive like that, because I think that looks good.
Yep, absolutely. I can make all those changes.
Okay.
Quickly.
All right.
And I don't think
we need
to the language. Sorry,
Jesse.
Chaos with the little squares here. Soon we'll all be in person again. Do we need to define what we mean by community members somewhere in here so that that's understood? Because I feel like that's do we want to hone in on that definition somewhere in the text itself? Residence is kind of self-evident. It's someone who holds an address here, right? But community members being more broadly interpreted, I don't know, do we want to say anyone who resides or works within Clarke County is what we mean by, do we want to define it that way somewhere?
I was trying to leave it as broad as we could so that we're not trying to, similar to how we took a citizen out, you know what I mean? And then we went broader to resident, and now we're going broader again, so that we're not dealing with where somebody lives, but the actual human being that where they are at the time is in our community. Sherry?
Well, I was just going to chime in. So the residents, that keyword and now to be community members are really only referenced in the recitals.
Okay.
And then once at the very end, here in section 4, about informing individuals involved. So that would be very easy to change. it's not usual to see a definition in a recitals section. I suppose it doesn't mean we couldn't say something at the beginning like community members, by which we mean X. But it just isn't typical to have a definition in that section.
Well, okay, so now that we're looking at this document at the beginning, it says, whereas the Mayor and Commission of the Unified Government of Athens-Clarke County is committed to taking consistent action to expand inclusion, diversity, and equity throughout Athens-Clarke County and the people within. I mean, is that a point we would be able to capture the people part? Carol, do you have an idea?
Yeah, well, I'm seeing what Sherry said, and then because really the resolution is the ordinance is the second half, and in there when you get down to 621, it says the opportunity for all persons to be free from. Persons then would include community members, residents, visitors, everyone else in the actual ordinance. So this is the introduction up there. So I think having the community members and visitors would be probably work for that part. The whereases.
So the way
Sounds good.
So the way it's showing right now. Avita, what you thinking?
Is Avita here?
Yeah, I saw her a minute ago.
I'm here.
Oh, there she is.
I'm just listening. I actually had printed out the copy and was reading it. I think when we did when we changed with the community members, I do think that is broad, and I think that it is even broader than the residents, because people, like I think Commissioner Parker said about folk may just be working. I like it the way it is. I don't think that a definition is necessary, but I wouldn't oppose it. But I don't think it's necessary. But I like the broadness, and I do like adding the visitors into the piece.
All right. Okay. Well, let's move this forward, and we'll let Sherry substitute all that in once the other feedback for the day happens. Is that okay with everybody? I did see down at the bottom, Sherry, where it ended up being at the end, where the businesses was listed.
The end of the recitals or the end of the whole
recital?
Okay, got it. Let's see.
I think there was a whereas or.
Sorry, I'm not.
Not.
Let me keep going. I'm sorry if I missed it.
I think it's towards the end. More the notification.
Oh, you're talking about, there you go. That's the end of the whole. Do you mean this one, to inform residents and businesses to include direct mail to all businesses?
Yeah, and so that would sub in for residents, and it's already clear which businesses it is within Clarke County. So that's already set. Does that? Okay.
We probably should change this to community members. I guess, we can try to inform visitors as well. It just would be a different tactic.
No, I think the and or is good, and visitors is good there.
Excellent.
Did you want to run through? I made you breeze past some stuff that you probably want to point out. Sorry.
Yeah, sure. Happy to do that. So let's see. I just highlighted this because I know there was discussion about racial identity or ethnicity here at the last meeting, and I don't think that I had clear guidance on what the LRC preferred as to whether to add it or not, in light of the memo that I sent at the last meeting. I don't know if you would like to discuss or if you'd like me to keep going.
Does that capture, as far as in the minutes, it was spelled out pretty good about the different things that we wanted to address, where some of the topics we wanted to do in this beginning part, which was giving our desire of what to work on, whereas in the ordinance, we might not have some of the legal backing to be as specific. And we were going to work on the whereas part being more specific. I think Jesse and Mariah, you had brought up family unit between the two of you. I think family unit as well as some gender identity, I don't know, just details.
Yeah.
I think you might be muted.
Oh, I didn't do that. What are you talking
Just
about?
maybe, just maybe.
I'm having a hard time kind of following along with the screen share. I was trying to look in my own document for it. But so Commissioner Houle, if you want to go first, I'm going to try to track down the part of I don't think this is the section that we were referencing, but I'm going to try to compare by taking a look at the document on a separate screen.
Okay.
Yeah, if I recall, is this racial identity was the term we were talking about? Is that right?
That's right. Yes.
And I think I remain in favor of including that, if that's, especially if I think it was Commissioner Parker who brought that up originally in the last meeting, but that sounds good to me. I mean, I kind of arrived in this meeting with two things I wanted to still discuss with y'all. One was about the familial status, considering things like polyamory and such, and then the other was about the schools. But if we want to tackle this first, the specific question of including racial identity, what do you think? What do others think there?
I think there's from having read the Sherry's memo here about it, there's actually a sort of a broader question that applies to all of them, because there's the question of what there's legal precedent for, and then the things that we had brought up last time that have to do with family, or this, I guess it was the mutable versus immutable characteristics, associated with, what was it, the racial identity, with, I guess, how you could fix your hair versus the hair and stuff. There were not the court cases to support any of these things. So it's sort of like, if we want to put them in there and they could be challenged, it's the same argument for all of them. It seemed to me like it was the same argument for all of them. So the question is, do we want to put some things in here which we believe in, agree in, but that aren't necessarily going to, most probably would not stand up in court if they got there? Is that summary correct, Sherry?
I think that's fair. I'm trying not to speak too much to that issue because of the confidential memo, and I just would like to let it speak for itself.
Oh, I'm sorry. I thought we were in confidential. I don't understand. I'm still catching up on things.
Yeah, we're in public. We're in a public meeting at this point.
Yeah, it seems so private here.
So the one memo that we have that says public in it was from Bill Berryman, dated 2016. That one was to help us in the public discussion and with the public understanding the differences of what is, well, in that instance, we were able to attach criteria, the dress code thing and the private party discrimination things that were happening to liquor license holding. And this this also overlaps a little bit with what we were talking about the other night, so that we do have things with our liquor license that we do have the ability to do, but we do not have the ability to do things in the private business sector. And that's where our toolkit was going to help us with some of the things at the federal level if somebody was having some discrimination, I think, in housing realm and that sort of stuff. But as far as what we locally can do, it does, to have teeth, we want to be with the criteria, the categories listed. And then I thought that what we were going to get an update on was, Sherry, wasn't it the 2017 case, Sherry, that you were going to look into that that we used as a racial identity as far as dreadlocks? That was one you were going to look to see if there was something more current about.
I did check, and there's not. It is still good law, unfortunately, and it's exactly what Carol was saying about the mutable versus the immutable characteristics, where we all may agree, pardon the pun, that the court is just parsing hairs, basically. But it's the question. The way that they break it down is if it's discrimination based on the hair, as in the style doesn't seem like the right word, but the actual characteristics of a person's hair based on their racial identity or their national origin, that is discrimination. If it is a style in which the hair can be worn, that is not illegal discrimination, at least according to the court at this time.
Interesting. I was able to find the part that I was making reference to in our last conversation. I think it was under the exceptions in section 6-20-4. So that's what I was trying to confirm, because it looked like we were looking at a different part of the document when discussing this issue, because I believe that what I was making reference to was that the ordinance does not prohibit an employer from requiring an employee to adhere to reasonable or equitable dress or grooming standards, provided that all employees are permitted to dress in a manner consistent with their gender identity as it currently stands, but wanting to also include racial and/or ethnic identity there. But from what I'm hearing from this conversation, there's no more recent case law to support that flying legally. And there's some other concerns with the addition of that to that section.
Right, not in the 11th Circuit, at least.
Okay.
Just where we are.
Okay.
It's disappointing.
Which is, but that is not to say that it could not be included. It's just that the case law thus far has not indicated support for that.
I think what I would say is the case law affirmatively says that it is not discrimination. So it's not that it is unclear or hasn't spoken on it, but there is an 11th Circuit case that is directly on point that says that employers can require their employees to wear their hair in a certain way, as long as it, again, it's related to a style, not to the specific nature of the hair itself.
It is so hard to separate that definition, Sherry. It just seems like it's mixed messaging, but I do not want to go down the path of putting in words or wording in an ordinance because we hope that it will change in the future. I think we should work to make that change, or maybe on another, level. But that just seems like it's mixed messaging. But I will definitely defer to your legal expertise.
So go ahead, Mara.
I don't want to belabor this too much. I just want to get clarity on what you're saying, Attorney Hines. So, for example, myself and Commissioner Myers are both wearing our hair down right now. Mine looks very different than hers. It could be claimed I'm wearing a certain hairstyle that Commissioner Myers is also wearing, but because of my genetics, it looks very different than hers does. So, is that, in that case, is that a style issue, or is that an immutable characteristic?
That is a really great question. I will tell you that I don't think there's a case in the 11th Circuit that has specifically answered that question, and that may be ripe for challenge.
Yeah.
I think most of the cases.
Getting at here.
But what I would say is that if we agree that, as you said, your hair is down, that's an immutable characteristic, as opposed to something like dreadlocks, perhaps. Although maybe that's not a good distinction, but just for sake of argument, let's keep that separate. I think that's a case you probably do win an employment discrimination argument on, and that would be under the current protected class of race. Okay. There would be no need to have a separate racial identity to be protected.
Well, that makes me feel better to know. Okay.
I would feel comfortable making that argument. Whether it wins the day, I don't know, but I think that would be a good argument to make.
Okay. That's very helpful to know. Thank you. And I appreciate y'all just let me think through this really quick.
Well, I think it's good, and I was reminded with some of our documents that I think one of our first rounds of this was May 2020, or one of our last. Anyway, there's a lot to be talked about, and I'm hoping that we can talk today enough through it to then broaden our conversation with our other commissioners in the community, right? By getting it out of committee and seeing how it bounces out there. And then making sure we can all explain it, like how we're learning here, and then we're also going to have to explain it out to more people, and for better or for worse, right, on some of that stuff. Mariah, you okay with this?
Yeah, no, that makes sense, and I feel comfortable, moving forward.
Okay.
Without further specification in that area.
Okay. I am aligned with, I think, how Carol had brought it up, and then Ovita, as far as staying with, I wanted the beginning part, the recital, to cover broader things than the ordinance. And I feel like that has happened. And that was my hope from our last meeting. And Mariah, we covered the specific sort of part in yours. Jesse, you, I think, had other specifics, but did the explanation that happened for Mariah's example also, can you apply that to yours, or do we need to talk through more specifically the schools and the familia status, which I think is not a category?
Yeah, so I guess, I mean, the example question around here would be, is there a way to recognize a polyamorous relationship as an actual relationship and the way that others are? And my understanding is that there's basically not specific case law against doing that, but there also isn't specific case law spelling that out. And it sounds like there's some dissenting opinions in Supreme Court decisions that leave room for that to be possibly included. And so given the seeming legal trajectory that opens that possibility, I'd be interested in including that. Whether it belongs under marital status or familial status, I guess I would defer to Attorney Hines on where you think that would better fit. And I'd be curious my colleagues' thoughts on that. Well, and then the schools, maybe we can tackle separately.
Right. Well, due to the fact that we've got an ordinance that is challenging as it is on no more than two non-family members living together, the ordinance that we have on the books. And so I think that we already have challenges with family definition. Mm-hmm. And so I don't know that, we have marital status, familia status, and due to the fact that those statuses have more listings of variety than I think we want to go with capturing that category versus trying to describe every version of it. Sherry, am I capturing that right? That just because under that status, doesn't that cover any type?
Well, that's an excellent question. I think what I would just say is the cases aren't out there yet. I suspect there probably will be one, and then not necessarily here, but someplace in the United States that challenges that for polyamorous couples in the future, or not couples, but families. I think the problem, I guess, is that the way that familial status has traditionally been applied is when we're talking about discrimination against families because they have children, or discrimination against a single woman as a parent because she doesn't have a spouse. I just don't know of anywhere where it has been applied to polyamorous families or less traditional, or maybe more modern, I guess, styles of relationships. I'm not really sure the best way to describe that, but I think it just, as you said, though, if we were to pass ordinance that said it was unlawful to discriminate against polyamorous couples as an example, then it would run completely contradictory to the definition of family that we currently use for zoning purposes. So that would have large consequences, and certainly that can be changed. It just would need to be thought about as to how that's going to happen.
Right.
Yeah.
Go ahead.
Yeah, I mean, I guess my thought is if there's this other law that it sounds like most everyone on the commission agrees we need to look at that's local, I'd hate for that to be the only reason we don't do the right thing on this ordinance, So
No, I don't mean that. I mean, there's more work to be done on that. I was just using that as an example of local, and then we're trying to deal with aligning with national and state laws to do this very important step that we've been working on. And in my opinion, I think that familial status should and would incorporate all the different versions that are out there. Whether it's, I just think that that the list is endless. And same with marital status or lack thereof marital status, right? Sherry, that there's such marital status. I would think that they would also be protected if somebody were to say something about lack of marital status. And then the familial status is a long list of ever-changing variety of that. I guess we've got a category, and you've picked one in particular that it's clearly of great interest to you. But I'm wondering what we're leaving out by trying to pick a specific familiar status to try to be specific about. That's what I meant.
Yeah. I'm following up the same line of thinking, Ellison, by asking Jesse, where would the change that you would want us to consider be? Just a clarification for me. Would that be in the definitions?
I think so, yeah.
So, and I think this is just what Allison was saying, and I don't know, and I might have spaced out for a minute, but in number 6 and 8, it doesn't make any reference to the number of people involved or the genders, the gender whatever the combinations are when I look at those definitions. So how would you change that? What would the wording be? Like if you had your dream wording in there?
I think my dream wording was to say relationship status,
Okay.
Which I think would encompass the variety of ways people can be in relationship that may or may not be related to marriage.
Okay, so it's changing that term. Yeah. Okay. That's helpful for me to understand.
And I think instead of giving it its own, I guess my question here for legal purposes is instead of giving relationship status its own additional category, if we used the term relationship status as part of the definition under marital status and or under familial status, if that makes sense.
And actually, if I'm thinking about that, Sherry, does that term, if number 8 changed to relationship status means an individual's past, current, or prospective status as single, married, domestic, like single, why not have religious relationship status if that's the way it's defined in terms of legally?
Because relationship status is not a legally protected class at this time. So, the fact that you may be in a relationship, whoever that is, the gender, there's no protection for that.
But how about all the things that are in the definition of it? Would it still not apply if it was single, married, domestic? Those things are covered, right?
Mm-hmm, they are.
So that group name has to stay marital status, even though the definition of it is it wouldn't change the definition of what's in that category?
Right. I would just say that marital status is part of the established protected class. There is nothing for relationship status. So, for instance, if someone wanted to kick you out of your housing because you had a boyfriend, not that there might be a novel case that addresses that, but there's no legal protection for that at the moment that I'm aware of. I'm trying to think of how that would work. I think the other thing, just trying to kind of play devil's advocate and think about how this would work, is that, we do run into the issues that polygamy is still illegal. And so if we try to make it very broad, then that sort of question is, well, how do we abut against laws that say that those kind of relationships are not protected, or at least can expose you to criminal prosecution? Not that I think anyone does get prosecuted for anything like that, but that just makes it a little bit harder, I think.
Okay. So schools. Jesse, what was the schools thing?
Yeah, I guess I'll mull over if there's anything I want to come back with on this relationship thing. But the schools thing, I guess, I think we were discussing around licenses, and because schools need to be licensed as schools, I'm wondering, is because that's not a local licensure, is that why it wouldn't fit into here? Is that what I'm understanding?
Yep, that's exactly right.
Yeah.
We don't
Now,
have any control over that.
For the schools that do get business licenses, would they be therefore under the purview of this?
I think they would.
Okay.
I can show you the definition.
And so basically we just have this strange issue where there are some private schools that do have licenses and some that don't. And have we been able to get any clarity on why that distinction exists? And I guess maybe the substitute question is, for the private schools that don't have licenses, is there anywhere we can point to in here that would apply to them as well?
I do not have any additional clarity from the finance department, and I don't know why some do and some don't. We could certainly try to reach out to them and get more direction on that, but I don't have it today.
To piggyback on that too, just to understand or try to picture that, and Jesse, I guess what I'm needing from you is, this going to hold you up from, voting in favor of this moving out of committee. But if the private schools, let's just say all the private schools are related to a church, doesn't that also sort of move them out of a lot of the monitoring, or gives them an anonymity?
Right. So we do have the exception for a religious organization, associate, or society, but only for the purposes of religious tenets. So I don't know that there's any religion that says, for instance, that you're allowed to discriminate against Black people or Hispanic people. So there is this exception. I don't think it means that religious organizations could then discriminate in every way possible.
Okay.
Chris, right, I think you are on mute.
All right, can you hear me now?
No.
No, I was on mute trying to tell you to go. There we go. Thanks, Sherry.
Welcome to the club. I had two things that I wanted to address. I don't know if we were moving on from the last topic or.
We're jumping around.
At the appropriate time, I had two things I wanted to bring up.
Could I say something really quickly to the school issue?
Yeah.
Yes.
So one thing I can say, Commissioner Houle, if it gives you any comfort, is that because that definition that we're proposing says which is required to obtain a license or permit, if we were to pass this as is, and we were able to later determine that these schools are required to get an occupational tax certificate and just have not been doing it, then this would still apply to them. If we are later able to determine that they are not required to do it, then there's nothing we could have done with them under this ordinance anyways. Is that helpful?
Totally. And just to clarify, this idea of the license being required, is that for this to apply to students at the school, employees at the school, or both?
I would think it would be both.
Both. Okay. Well, then if I'm comfortable with leaving it as it is with regards to the schools question. This is kind of just helpful clarification to have in the public meeting. Can I ask one more question about the polyamory thing?
Well, yeah, you can. I wasn't trying to. I wanted to cover some other stuff too.
Sure.
So I think we've gotten 2 out of 3, And then I also just wanted to identify that finance not getting back on something. They are deep in all of our budget questions right now, so we can give a little empathy in that direction, but also know that we can continue to build on that, right, as this moves through our processes. Okay, Jesse.
Yeah, I guess I'm just wondering, it's not the place I'd ideally like to see it, but would it make sense to put polyamory in the listing under sexual orientation, which is often how it gets talked about in other places? So including but not limited to homosexuality, heterosexuality, polyamory, or bisexuality.
I still think because it's not one of the protected classes, but Sherry, I'm not going to play attorney here.
No, I was going to say, I would just advise you all that I'll stand by the memo that I sent out previously about that issue. I think that you certainly can add it if that's what you'd like to do. And I think that certainly makes sense as a place to put it. It would just be up to you all as to kind of how far you want to go with additions.
All right, so we've talked through everything that was in the minutes that was the get back to. And I would welcome if we're at that point after the changes happen to it. All right?
Yeah, I had just two things. I actually spoke with a woman that has been involved in writing these all over the state, just to get some input from some various other ordinances that have recently passed. And two things that were brought up were potentially scratching where preempted by state and federal law under 6-20-5. In the Decatur ordinance, if you could file at a different level, you can't file at the municipal level. And so taking that out to avoid redundancy, I guess, was the idea there. And so I don't know if you have any thoughts on that.
Can you say that section again?
Yeah, so it's section 6-20-5.
Enforcement.
Yeah.
Okay.
Right.
So where preempted by state and federal law, it may be redundant.
Is this the part that you're talking about, Commissioner Parker? This part.
Again, can you scroll up a little bit to see if this is the section?
It is the section.
This is 6-20-5.
Yes.
Yes. So I think that was the section.
It's my understanding, Sherry, isn't that where we were merging parts from the DeKalb ordinance with the Brookhaven?
It is
the hearing officer thing.
Yes. I honestly at this point can no longer remember which one this came out of the original.
Okay.
But I will say this part was actually something that we thought was really important to have.
Okay.
And the reason is that it's not. I think I would say two things. That one, I don't think that pursuing an ordinance violation in any way, shape, or form precludes someone's ability to pursue relief in any other court. So I think that they can move at the same time. But secondly, this really is there designed to provide the government and the entities who are accused with some protections, in the sense that if the administrative hearing officer reviews the facts and determines that this would be preempted by federal or state law, then he will or she would dismiss the case. It would not move forward, as opposed to a situation where if this does not exist and it just goes forward, and then perhaps a person or an entity that has been accused of violating this organization just moves to filing a lawsuit against the government.
Okay.
Does that help make sense?
It does make sense. And then the other, this phrase is also repeated in the whereas section. I believe it's paragraph 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. Paragraph 11.
Okay, this one?
Yes.
Okay.
Is it necessary there as well?
Where is?
I'm not sure that. Well, I would say that it is necessary. Yes.
Okay.
And my reason is because the recitals only exist to provide background information for why the Mayor and Commission made the decision that it made. And I would say that this part is the part that ties this to the occupation tax certificate, which a lot of people consider a business license, and it indicates why we are taking action against entities that have that occupation tax certificate.
Okay.
I don't know if that answers your question, but I think that's that tie.
Yeah, that does make sense.
Hey, Sharon, well, there's a typo in the whereas in that statement. There's a missing E.
Oh, I see. Thank you.
But my next question regards the definition of religious organizations and I'm sorry, I can't remember what section that is.
Right here, number 12.
Number 12. So, and it may also appear elsewhere in because I'm actually not seeing the thing that was concerning me in this here, but perhaps elsewhere in the document when we refer to religious organizations. Here we make very clear that we mean an entity which conducts regular worship and is qualified under the IRS code. But elsewhere we also make reference to religious associations and societies. It's not necessarily the same thing. Mm-hmm. And so someone could say, well, we discriminated against someone because we are a religious society, but they are not technically by law a religious organization. I think it's really important to adhere to that that definition throughout.
Sure. Since religious organization is a defined term, we could just take this out.
Yeah, that's it. Yeah.
Okay.
Good. Great. That's it. That's all I had in addition to, what I brought up earlier.
So, Mariah, that's, I've missed that totally because you could go about anywhere with that association or society thing.
Yeah.
Right. Good eye. Okay, with those updates and then having, the beginning substitutions for community members and or visitors. Carol, what did you have your hand up? What's new?
I had just two very minor, revisions. Actually, one revision and one question, just so I can answer this when we get it. I've kept asking myself. The one revision is just the process in number 3 on under enforcement at 625, and I was thrown off. Let you get there.
There we go.
625. And the sentence that says, so do we be responsible? Yeah. Gosh, mine goes on to the next page. After.
It does.
Yeah. The sentence go back. It's right there. The county attorney is authorized to utilize alternative enforcement measures on that sentence. And you can go figure this out later. We don't have to discuss it. But my thing was like, doesn't that really belong after sentence 1 in the order? It seemed to be out of order there, and I was a little confused. So you can consider that. If it's not appropriate, you just do what you want to do with it. The other thing, just from my understanding, because I keep wondering this every time I reread it, what is a bona fide nonprofit private club?
Oh, that's a great question.
I don't know of any examples. Is that a specific category, Sherry, that?
It's one of the things that they put in. So when we say a nonprofit private club, I'm willing to bet that was designed for country clubs. Anything that is a nonprofit entity that also has private membership is my guess. But it's not a defined term in this document.
So, and if that's the case, I'm just curious, what's the legal precedent for that? So I was just at something at the country club. So does that mean that if you're at the country club, you can do all of these things and discriminate against your help or the way someone's, because of all these other things? So that's, clarify for me if that's what it refers to. Why is that in there? Is that state law?
Right. So I'll admit I'm not very familiar with private clubs, but I just looked it up. They are typically considered 501c7 organizations. They have to qualify by a number of different things. They have to have limited membership and be organized for pleasure, recreation, and other non-profitable purposes. My guess is that they are generally exempt from a lot of different types of regulations. I'd have to do the research on that, but I would be willing to bet that there's state law or federal law that exempts them. So we can research that though before the next meeting or before this goes to the Mayor Commission.
That would be great. Thank you, Sherry.
Mariah, I kind of remember that we talked about a little bit of this stuff when we enacted our private part, the whole thing about private party downtown.
Yeah.
And we were also trying to get in the loop of people treating their public facility bar downtown as a private club, right?
Yeah.
We touched on a little bit of that, and I think that that's covered with the current ordinance that we have about private parties and posting it, date, time, who, when the party's over. I think they do them downtown a lot, like from 8 to 10 or something like that. But that because of the liquor license, we do have the ability to have some criteria on what we have right now. And that's where I think, with the toolkit that should be following from this ordinance, that we can start getting more word out. And when that happens, I think that we'll be diving into some of these other details, if that's okay for you guys, for us to have more toolkit wise versus the ordinance. Does that sound okay? For the second part of this assignment? You follow me? Because it's separate. We've got it. We've got the assignment is divided so that we can move the ordinance and the recital forward to the Mayor and Commission, and then we're going to be working on the second half, which is the education toolkit of how to report and stuff like that.
Yeah.
And I suspect this example that you just brought up, as well as some of the other things we talked about, are going to get fleshed out in deeper detail for that.
Yeah, and also maybe Sherry can just find out, because we're saying this is not applying to these clubs, and I just want to be able. I'm sure someone else is going to ask about this. Like, so if we could just have explanation and why that doesn't happen, so we can either defend it or delete it when we're among the larger group. That would be great. I don't want to hold this back.
Right, and it also could be that we learn about that and make sure that we have some sort of criteria with our liquor license. Because if it's a nonprofit private club with a liquor license, there's other things that is something that we can have. I don't know. I'm getting it confusing, so I'm going to quit talking. So, is there a motion?
We'll research it.
Yeah, we'll research it. Is there a motion?
Can I?
Sure.
So I want to move this forward to the full commission, and I'm excited to support it however this goes. But I would like to my understanding of the legal memo has me feeling comfortable with this. So I'd like to make a motion to amend under the definitions section 620-2 familial status to say means an individual's past, current, or prospective status as having multiple intimate relationships and or as and then the parent or legal guardian part. So I'd like to make a motion to amend the text that way. If I can get a second and we could take a vote, great. And if not, then we'll move on.
Is that, I would be open to seconding. I just wanted to check in with Sherry one last time before we do so.
I think I've provided you all with the guidance that I can provide, and it's just up to you all to make that decision as to how you want to move forward.
Okay. I'll second.
I would just add an S at the end of relationships. But
Thank you.
Yeah.
Does that look right?
That's perfect. Yeah.
Some people would say all marital status isn't intimate. That's a whole nother category,
Yeah,
right?
well, that's why it's under familial status.
Yeah. Ovid, are you there? Okay. So I will call a vote. We have a motion and a second. And we'll do a roll call, even though I don't know if I've ever done that before. But So we'll start with the motion. Jesse, Jesse, how do you vote on this?
Yay or aye.
Yay.
Mariah, how about you?
Yay. I'm going to start doing that all the time now. It's way more fun than
Yay.
aye.
Carol?
Yay. We're approving this wording and moving it on to the larger commission, right?
Well, I was hoping we wouldn't approve it to move it on forward, but we're voting on inserting this into the document.
Oh, okay. We didn't vote on any of the other insertions. Okay. Yeah, I'm fine with having it in here, and whether or not it stays in as we discuss this further and I sort of think about it logically, I'm fine with having it in here. Yes, yay.
Okay. So, and I'm a no. So that's three, as we say.
I'm a no. I'm sorry.
Avita, there you are, Avita. Hey, Avita. So, as Gene Spratlin would say, it's 3-2 passes. Let's just do it. Let's do a group thing because Carol, you did make a good point. I thought we had a lot of head shaking for everything else. So the other things that we talked about today in there, do we have a motion to cover those as it moves forward? Carol, you were shaking your head. Is there something we talked about that you didn't want in
No,
there?
I just didn't. It was just process. It was just process. Okay, so moved, or I'm okay with the rest of it. If you want to vote on the other changes or not, either way, as chair, your decision. I'll go either way and approve.
Well, I didn't want to leave anything. Just trying to read everybody, which is little. It's hard to do in the little box. So is everybody okay with everything else that's on here so that when we move forward, the continued discussion about us moving away from the protected statuses for one sentence and one category versus staying with all the protected categories in the rest of it? That sounds like that'll be our main, the difference of our discussions here, if everybody agrees with everything else. Is that right?
Mm-hmm.
All righty. So I will we'll get an agenda item for this and see where it drops into the mayor and commission cycles. I think that's our next step. Sarah, do you have some dates for us on how that would process out of committee?
Not off the top of my head, but I'm happy to pull that up for you. And we can go ahead and we'll drop it into the earliest agenda cycle that we can. But if you bear with me, I can pull up a date for you.
Okay. Let me get. So then the next item, we were going to talk about examining the opportunities for an educational toolkit for the local civil rights legislation. And it might be that would we want to put that on hold until this part of the ordinance gets all the way through? Sherry?
Sorry, just before again, I do think we do need a vote to move this out of commission or out of LRC to the full commission. Is that right?
Okay. So
Yes.
we made a motion to insert. We made motions and topics on the content.
Mm-hmm.
All right. So that was a 3-2 vote. So now I'm looking for a motion for this assignment from March 3rd, 2020 to be sent to the full mayor and commission into the next agenda cycle.
So moved.
Moved. Second.
Carol, Jesse, all in favor?
Yay.
Yay.
Avita?
I, but I'm on mute, so.
Okay. I hear you now, though. Okay. All right. So we're moving it forward. And we'll get the dates on that when we start talking about dates. I think it's towards the end. So the topic of examining opportunities for the educational toolkit on local civil rights legislation. I was wondering if we would want to we'll put that on hold until this gets through the mayor and commission, because we also have to review and make recommendations regarding current alcohol serving opportunities for special events on public property. And since things are opening back up, I didn't know time-wise if we would want to move that up into committee work while the ordinance we just talked about, non-discrimination, is going to the mayor and commission. So let's hear what people think about that. Carol?
Yeah, I looked over this. What do we call it? Basically the communication and outreach on this, and I was kind of curious. It seemed to me that it was something that our staff could flesh out, and it's a process for making it clear online in communications, reaching out to the community, that it was very, it was not policy, but it was procedural. And I was curious why we had to deal with that in the LRC. Like, why aren't, just to help me understand, why aren't we just letting them figure that out?
I had the same question.
All right. Who would like to address that question?
Well, I can give it a shot. So based on kind of where we've been with this, so we actually started in the July 2020 LRC meeting. Our inclusion officer, Crystal Corcoran, who is on this call, she had been requested by the committee to come in and to discuss some of the other complaint processes that have been happening that she had researched across the state. And to review our processes to try to make it as accessible to the community as possible. And there was also discussion around, so not only helping our community members navigate our processes, but also making sure that we had processes in place to help our community members navigate other external processes as well that may be available to them if they feel that they've been discriminated against. The two examples that were brought up were for employment discrimination, the EEOC has a process, and similarly for housing, the HUD has a complaint process. So in those discussions, our inclusion officer was asked to provide some recommendations on how we might make our existing processes more inclusive and accessible to our community members. And she provided that Making Discrimination Processes More Accessible document that we shared with y'all. And it basically outlined 3 strategies for the committee to consider, which included reviewing the existing discrimination complaint process to identify areas where we can break down the processes into actionable steps to provide clarity, to explore tangible ways to bring information on the existing discrimination complaint process to residents to help raise awareness, and then to continue to assess and evaluate our current discrimination process. So my understanding, based on our February conversation at February 2021, now that we have a lot of years in the process, was that we were looking at possibly getting committee input on how we as staff could best, what kind of qualities y'all were looking for in a centralized mechanism to help make these processes more accessible. So I think from a staff standpoint, and I'll refer to our inclusion officer in a moment to see if she has anything she would like to elaborate on. But I think really what we're looking for is there any direction that the committee wanted to specifically cite to help us tailor our current existing discrimination processes to help our community members navigate those. Madam Chair, is it agreeable for our inclusion officer to elaborate on anything I may have missed or misspoken?
Well, you did a great job, and I do want to hear from staff who are here for that, the very reason of the topic that's at hand. And I did forget about the July 2020, how long ago that was, and the makeup of our committee now. So, yeah, I'll be ready to hear what Crystal wants to add in as well.
I think Sarah just gave a very comprehensive summary. I don't know that I have any additional details to add with regard to the history that brought us up to this moment in time.
Okay. Well, am I hearing from the committee to the utmost confidence that we have in staff to do their thing and then come back to us versus us trying to bat it around in here?
It makes sense to me to get perhaps like a commission work session on what the toolkit could look like, rather, since it isn't necessarily a legislative review issue, it makes more sense to me to have full commission's input and some dialogue on that rather than discuss it in this body. So I'm cool with that. You got my vote. Yeah, I trust you, Crystal. Go again.
Well, okay, well, that's good because I also felt that when we divided the question, it was allowing us to not think about that while we focused on the ordinance. So we're kind of doing both really well today by separating it as well as not. And then I think that what we would learn from making this communication and outreach, so to speak, Carol, that was a good way of, defining this educational toolkit that we're talking about. And I've always felt, especially after Crystal's input in July, that it's whatever the improvements we can make are going to be applicable for all of the outreach and education that we need on all of our topics. So, Mariah, I agree that having that presented to the whole group is going to be relevant. And then hopefully it can happen at a time where the ordinance, and we can use that as the impetus, right, to get out there. So
I want to clarify something with you, maybe Allison, or with Crystal. Is the third idea on that, clarify goals and scopes, is that something we have done based on once we get this ordinance passed? Although there's this third part that says seeking feedback from residents, but I don't know if that's about the process of getting the information out. So have we done the third one, clarify goals and scope?
No.
Commissioner Myers.
She may have. Go ahead, Crystal.
So, Commissioner Myers, I am in a similar position. It has been quite some time. What I can share with you is as follows. There have been a number of internal conversations across multiple departments and offices around what steps need to be taken in order for us to make these processes as accessible as possible. Within the Inclusion Office, we've begun to identify that there are a number of existing discrimination complaint processes. The Attorney's Office has assisted us with that. Examples would be, in addition to the HUD process that's external, there is an internal HR process, for example. There's a process that lives inside of our police department. So there are multiple pipelines that are available, but these pipelines are not necessarily transparent or accessible to either our residents or our staff. So then the question becomes, what can we do about that? And one thing that we can do that we've discussed across multiple offices and departments is create one centralized location that everyone can go to be able to identify all of the discrimination complaint processes that are available. Once we're able to do that, we need to ensure that as people are participating in the processes, they understand all of the steps that are involved, because there are times when the fear of not knowing what's going to happen next can then become a barrier that stops someone from actively participating. It can be anything as small from, let's make sure that it's an online form that can be filled out, to making sure that on the form it's breaking down exactly what's going to happen next. As far as the outreach component, people tend to receive information from those that are known and trusted. And so we need to find ways to partner up with existing community organizations in order to provide education around the centralization of all of this information, and also to begin to understand whether it's possible to deliver some sort of a navigation support mechanism. So let's say someone reaches out and they need to file a complaint. If there's specific community organizations who assist with navigating a specific process, ideally our local government would work in partnership with each organization so that our residents are supported as they're navigating the complaint process. In addition to that, we need to make sure that we're tracking things all the way through. So an example of that would be, if we're receiving a set of complaints in a specific area again and again, then the Inclusion Office needs to work in collaboration with organizational development and potentially other departments to think through trainings that might need to be made available to staff, so that we're tackling it on the front end and on the back end, and we're tracking it over time so that we can identify trends. Those are some of the pieces that we've been working on and discussing in the interim.
Thanks, Crystal. I think that clarified it. And I was so focused in on this one process that I didn't see the complaint processes and think of the other ones. that you're referring to. So that makes perfect sense, and that helps me understand. Thanks a lot.
Okay, committee, do we want to then, I'm looking for potential motion on our second item that we just talked about with action.
I'll make a motion that we we ask whatever staff to follow through on this and follow through in developing these processes and prepare some kind of presentation for the larger commission at a work session.
Let's capture that with being the manager. Just go with the manager. Is that okay, Carol? If we say ask the manager, and then that'll trickle out as needed from there. Okay.
Yes.
There's a motion on the floor.
I had a quick question. Did we want to? Is there a desire? Is there appetite to like specify when we would like to have that work session, or does that put too much pressure on staff to get something done in a time?
I think with being in the middle of budget and
and then July
plan and T-SPOS, and so let's just. But I think the good thing is that it can come out of committee now in the same agenda report.
Yeah, that's cool. Well, I'll second Carol's motion.
And hold on, Sarah, is there a question before I call the question?
Yes, I just wanted to clarify. So we are looking to pass this out of committee with no action in favor of a work session. Am I understanding that correctly?
Yeah.
Okay.
I'd say with, I would say with action after a work session. I don't know, committee, what are you thinking? I hate to say there's no action.
With possible action after a work session. So I want to pass it out here to the manager's office to develop this plan in more detail for making the complaint process more accessible, for make it more detailed for a work session with possible vote by commission subsequently after that.
Okay. And then the second, Mariah, were you the second?
I was.
Is that okay with you? We're still a second. Okay, now, all in favor, say aye.
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 Okay, and it passes unanimously, I believe. And I think to your point, Mariah, after the work session, if what we learn is not LRC, you know what I mean? If it ends up being with government operations, it could switch over.
Yeah.
Yeah, good call. Okay, so we have about 15 minutes left of our meeting, and I was wondering if we could get a start on the special events assignment. Sarah, I'll let you.
Perfect. So this topic was last assigned, or was assigned by Mayor Gertz on February 4th of 2020. And we last discussed this on February 27th of 2020. So this was pre-COVID conversation. And during that conversation, we heard from our police department who outlined that from their standpoint, the biggest issue that they've seen related to our current alcohol serving opportunities with special events was crowding of people in small tents, which tended to cause some difficulty in extricating people should there be an emergency situation, or if there were people who may have committed a crime against someone, like pickpocketing, and pursuing those people. So from that conversation, we heard from our essential services staff who are also on the call. So on the call today, we have our Assistant Director, Gavin Hassemer, with our Central Services Department, and we have Angel Helmley, who is our, I believe, Operations Coordinator. I apologize if I got that wrong. But they kind of outlined what our existing process looks like. And we, where we last left this, was staff was going to return to the committee with recommendations to improve the ordinance based on their experiences. Obviously, COVID hit, and some of our existing special events processes changed. So with the emergency order that was put into effect on March 16th of 2020, staff temporarily discontinued issuing special event permits. And then that was resumed on May 1st, 2020 for marches, rallies, or any other constitutionally protected activities. Subsequent to that, our central services staff under Manager Blaine Williams' direction, issued a notice of proposed administrative action related to our special events policy that is specific to our special events under COVID precautions. So we provided that to you as new documentation, and then I've also shared with our committee members, since there are new committee members since this was last discussed, our documents that we previously shared. So with that, if it's agreeable, from, I guess, a staff perspective, we really would like to hear what questions or other direction we can provide, but I will turn it over, if it's okay with Madam Chair, to our Assistant Director, Gavin Hessmer, or to Angel Helmley to discuss their perspective further.
Sounds perfect. Thank you guys for hanging with us and getting us kicked off so what we can start in full for the next meeting.
Yeah, thank you. And I will certainly allow Angel to take over in a second, but I just wanted to thank Sarah. That was a good introduction. Being that it was over a year ago that this idea was sort of floated around, and then COVID hit, and we've had to make differences in how we operate special events just due to COVID over the past year. I think it would be great to get some additional direction from this body as to pick up that conversation again, almost fresh, and make sure that from a year ago, any conversations or discussions that took place are still on your mind, are valid, or any other questions that you might have for us to work on. We certainly can provide information with any questions you may have, but from a recommendation standpoint, we don't really have anything for you right now, given the current circumstances with COVID and it being a year since this was last discussed. So in our minds, we're sort of waiting for additional direction from you all. And I'll let Angel quickly add to that.
Okay, I just wanted to say that just so we get it in perspective, we're talking about less than probably five events a year. We usually permit about 55 events a year, but some of them are really small, and the majority of them do not involve alcohol. So I think that's important that you know. Some of the issues that came up last time and that we discussed were the current ordinance requires seating for however many people are allowed into the beer gardens. It requires food service be available. It's specific about the beer gardens must be rectangular in shape and must abut the curb. And I know those were some issues and complaints from some of our users, so those may be some of the items y'all want to touch on. Right now, I mean, we're starting to issue special events again based on the notice of proposed administrative action that you all received. We're going by those guidelines. But if y'all have any questions, we'll be happy to answer them.
Okay, thanks for that review. It does seem like an awful long time ago, and I do remember us thinking, Mariah, I guess it was you and I and Ovita on that before. Imagine, I'm sure we all have experience in the beer tents, but it's just the chairs got scooted to the side, and we're almost a tripping hazard versus and the count that they had to have, and it also cost lots of money because they had to rent the chairs. And now I like the direction we were about to go in to loosen things up. But now that we've got our parklets and other things to consider, I'm looking forward to our new discussions with new situations. So let's just go around the group and hear what you guys are thinking. So we'll be ready for next meeting. Jesse?
Yeah, I just have a clarifying question. So the scope of this assignment is only for events-related activities. So I know Parklets has precipitated our desire to get through this more quickly, but we're not going to be discussing policies for like alcohol in Parklets generally outside of special events. Is that correct? This is only for special events?
That's right. Special events with alcohol, I believe, is and Angel, I really appreciate you bringing that down to us to 5 events in a typical year. I suspect we're going to be making up probably 5 this year and then 5. But anyway, who knows? But I think that what especially with College Square being closed, maybe the ability to be a little looser with a lot of the things. I mean, geez, you can order an entree and have 2 drinks to go now. I mean, things quite different. But
Yeah.
but yeah,
we won't be tackling if someone does that any other time except these 5 events of the year, right? That would have to be a separate committee assignment. Is that?
Right. I was just saying
Okay.
for consideration. And Angel, go ahead.
I just wanted to let Commissioner Hull know that the parklets are being reviewed by I think it's the GOC committee. So, I mean, that is something that's being discussed, but I think it's with the other committee.
Yeah. Okay. Well, so I'm sure we can have some discussions among each other and learn the direction they're going. Jesse, does that wrap up what you wanted to say right now? Okay. Carol?
Yeah, just so I can get this in my head, what we're working on, 5 events. So I assume Athfest, Twilight. What are the other 5 events? The other events?
I'm sorry. The 5 was just an average number. Sometimes it's less. It is Twilight. It's Athfest. We had a St. Patrick's Day festival a couple of years ago. We didn't have it last year because of COVID, but I know they're wanting to make it an annual event, and they have alcohol. And not last year, but the year before, Creature Comforts had an event out in front of their business there. That's the only 4 I can think of off the top of my head. So right now.
And these aren't by size. This is like special events that want alcohol. Is that correct?
Yes, that's correct.
Then you mentioned issues, and I just want to see that these were some of the issues that are associated with this policy that are requiring it to come here. In terms of the seating, what kind of seating? Was it like 1-for-1, or like what was the seating policy?
It is 1-for-1. We have 2 different size beer gardens. They can either be for 150 people or 300 people.
Okay.
And it's 1-for-1. So if there's 150 people, they have to have 150 chairs. If it's 300 people, they have to have 300 chairs.
Okay, so then the next thing was food service. So I'm remembering like at Athfest, the beer garden, were they serving food in there?
I don't know. Unfortunately, I'm not down there but that is part of the policy that they have to have food service available. It doesn't mean food has to be inside the beer garden, but it means that there is food available for people to eat.
Okay, so it could be at other other trucks and other things down there at the event, not in. Okay, that clarifies it for me. So it's not necessarily there. And the last one, it has to be a rectangular and abut the curb. Was that correct?
Yes, that's correct.
Okay, so that means. And what was the reasoning for that? So that means that beer garden down there with Athfest, I can't remember, but I was actually going up on the curb to go around it. I mean, that would have been theoretically what I would have had to do. It has to be shifted to one side.
Carol, it was like a little Tetra game. You had to move these beer garden squares around, and if you wrapped around a corner, you had to be, and it also had to do with checkpoints for being old enough, police sight line. Gavin, you want to chime in on some of those details?
I think what Angel was about to share too is that the reason it needs to be along a curb, and there are certainly some leeway to that design, as you just pointed out, but it just can't be in the middle of the street. We still have to keep those clear for emergency vehicles. There has to be access that they're not obstructed should an emergency occur where we're having to move a beer garden because it's in the middle of the road.
Makes sense. So are those really the 3 issues around this review that we're looking at? Were there other things, or was it mostly these 3 things that we're tweaking?
I think some of the event sponsors had requested that it be considered, open container be considered for events.
Outside of the beer, like you could get the beer and walk around.
Mm-hmm. Yes, that's correct.
Well, that's a big one.
Right. Yeah. And that would be something that I think should be discussed with the police department, to get their input about what they think they can handle and control.
And did you guys have a presentation from the police department or anything on that?
We did. I believe that Chief Spruill shared with us some feedback and experiences he's had other places on it. Angel, does that come to mind to you?
It does. Captain Epps has also been vocal on that. And I know in speaking to Captain Epps in the past, I mean, he didn't have a problem with the open container concept, but to him, it really depended on the size of the event. Twilight is a huge event that draws in about 10,000 people. And I think he was leaning towards it's just not doable for an event that size. Maybe the smaller events it would work for, but I don't know if y'all want to make that decision to vary between the size of events.
Right. And that kind of touches too, committee members, on the amount of feedback that we need to get thinking about again, as well as the different professionals that are going to speak to that. Some of the things, Carol, that came about were checkpoints where people had bracelets that they were 21 and over. Some events they sell a cup so that if you had a beverage in a brick and mortar bar, you could pay to go to be out in the open, but you also had to have that bracelet that showed you were 21. And if you got caught with an open container that wasn't the paid for open container, that meant you were 21. I mean, there's checkpoints that have to be done for it to be feasible. And I believe that Chief Spruill had experience with some of those different options. And I've been at a place in Memphis that was similar to that. So I look forward to us talking about these different options and learning what might be feasible. And I think the feedback from Angel on, like you say, event size, or at least having an estimation. Some of them we know, and like the St. Patty's one, they want to grow. So it could be. There's a lot of options to it for us to study.
In the next 2 minutes here, I just want to ask one thing. Is it possible for us to get some of these event organizers to share their, or is the concern coming from Matt from Clarke County? And I guess it is to make some changes here, but during this process, can we also hear from some of those event organizers as well? What's the standard in terms of LRC and hearing from outside?
We do it all. We do it all. We want the pros and cons from the people who do the special events permits. We want the professionals, staff, and the feedback from those who, and then we have the attorney's office to make sure that we're doing things to avoid liability as well. But yeah, we'll have all that, and one group will bring something in that we'll learn from and spin off. So we want to study it thoroughly, but we also want to be ready for fall if we can. All right. Yes, Gavin.
Commissioner Wright, just real quickly, is there anything that prior to your future discussions on this that you would like staff, central services staff in particular, to take a look into or to prepare for any future discussion?
Right, because our next meeting is June 3rd, I think, coming up, to get back on our first Thursday of the week. I guess if we can stick with you guys in central services, what do you think we need to be hearing about? And maybe do you think bringing the police department representative in to overlap with you, is that going to be the best next step from your side?
Yes.
Okay. And
yeah.
Go ahead.
And I'm assuming we're not trying, isn't AthFest, aren't they set up to do something in August, or what's the date?
September 20. Angel, what is it? September 22nd, 23rd, something like that.
I got my calendar here. AthFest is September 24th through the 27th.
And Twilight, did they put one in?
Yes, they did. Twilight is August 20th through the 22nd.
Okay, so now that we have those targets to shoot for, but we also have heard that the Twilight is too large for some of these changes, but the beer tent changes, we might tackle it in that manner as well. So on that note, we have our next meeting is scheduled for June 3rd, after our June 1st vote. And so we'll stick with this topic. And then let's look at our calendar for where we can reschedule July meeting, because it would be on the 7th, but that's our no meetings block out. What does the LRC meeting of, I think we come back on July 20th with agenda setting, which looks like that's when our non-discrimination ordinance will be on the agenda for an August 3rd vote. That's where that's going to drop into the cycle. Thank you, Sarah. And so what do you guys think about Thursday, July 22nd? And then I'll talk with the mayor if we come up with some things that need to be fast tracked to help with those events that Angel just told us about, that maybe we can come to some decisions there.
I will
Yes.
not be able to do the
20
22nd. I have my final course certification class with ACCG that day. But I can do the Tuesday or Thursday of the following week, so the 27th or 29th, if that works for everybody.
Well, if something comes out of committee and we want to get it to the vote, right, on August 3rd. So, yeah.
Can
I think
we just, sorry, Jesse.
Go
Can we
ahead.
meet without you?
Yeah. No, I mean, I don't feel like I don't feel particularly passionate about this topic, and I feel like we're mostly gonna, like, staff's gonna know what they need, and we'll be like, yes. So
Yeah.
that works.
I think it'll be, we can iron this out probably a little bit easier. And you know what, Jesse, I'm sure something passionate will come forward from you about this, and that we will know it, and we will hear about it, and we'll deal with it accordingly. So no, you might not be here, but we won't leave you out. How's that sound?
Sounds good. So so
Okay.
we're expecting 2 more meetings on this to get it done. Is that?
Maybe not. We could be there where we tackle the seating, the chairs in the tent, some of those more improve what's already there versus trying a new strategy. We could also divide it, focus it that way too. But let's learn from staff on that. Does that sound good, Gavin and Angel? All right, in the attorney's office, they're like, "Oh, this is a piece of cake," after compared with. Okay,
So
all right, guys.
No LRC July 1st.
Pardon?
No LRC July 1st.
Oh well.
No, I'm
no,
sorry.
No, yeah, we have a block out of meetings that's mid-June till July 20th, and we're going to stick with that.
Just mid-June. I don't even know.
So yeah, look at Jean's updated calendar that she
Okay,
sent. And at the
cool.
very bottom, she's got the dates of no meetings, and then she pointed out that included ours, and so we're going to make sure we still have a July meeting. Right?
Music to my ears.
Is that all right? Okay, I'm looking for one more motion.
Motion to
Adjourn.
All right, there. Avita's got the adjourn. Who's going to second?
Second.
Carol, all in favor, say aye.
Aye.
We did it. All right, thanks, everybody.
Bye-bye. Thank you.
Bye.
Bye.